Hi, I'm Jennifer Novak, and I'm an environmental attorney representing businesses throughout California. If you're one of the thousands of California businesses covered by the General Industrial Stormwater Permit, you should know that federal law allows a concerned citizen or group to enforce the terms of the Clean Water Act. So today, I'm going to walk through some of the basics of a Clean Water Act citizens lawsuit. Now, first, federal law doesn't allow people to simply sue a business for Clean Water Act violations. They have to first serve the business with a 60-day notice letter. The letter has to explain how you've violated the permit and give you time to fix problems without facing a lawsuit. Now, 60 days may seem like a long time, but that goes fast. So use this time to audit yourself, to check whether there are actually violations, because it could be that they don't have the correct information about your operations or your compliance. So this is your chance to educate them. But what you shouldn't do is ignore the letter. Even though it doesn't look like a formal lawsuit, it's the first step toward one, and you're not likely to get a follow-up letter or a phone call. Instead, the next step is you're likely to get served with a lawsuit. So the reality is that if you received this letter in the first place, then at a minimum, it means they've checked out your online reporting. They may have physically checked out your business to make their own observations. And they may even have taken stormwater samples during a rain event to see what kind of pollutants are coming off your site. So what this means is that ignoring the problem doesn't mean it just goes away. That begs the question, what does it take to settle a lawsuit that's been threatened or actually filed? There's going to be a few action items that go toward fixing past problems and avoiding future ones. That's going to just be part of your settlement. There's usually going to be a mechanism for the lawyers or the citizen group to come and inspect and follow up at your business over a period of time to make sure that any problems were fixed and are actually working. And then there are usually financial provisions, which can include things like environmental projects, the cost of future monitoring, and more importantly, the cost for having the other side's lawyers and consultants perform their investigation and write the notice letter and anything else that was needed to reach the resolution. So if you're wondering then, why settle? Why not fight? Well, as I've noted in some of my other videos, this is an area of law that is strict liability. And usually a citizen or an environmental group has done some homework before sending you that notice letter. As you evaluate their claims, you may find that they are right about at least some things. And if they can prove at least some violations, it gives them leverage. So the longer you negotiate and litigate, the more their lawyers will work on the matter and the more time they're going to want to recover. So pick your battles carefully. Now, as a final note, there are concerned citizens and then there are concerned citizens. Certain groups or lawyers are becoming notorious for sending out hundreds of notice letters at a time and then looking for quickie settlements. Before you settle, you're going to want to know if you're giving up too much, if you're leaving yourself vulnerable to future threats, and if you've agreed to do something that you're not actually legally required to do. Because of that, it's important to get advice. And if you have any questions about how to respond to a 60-day notice letter or whether you're getting a good deal, or if you just need someone to yell at because the whole thing sounds like extortion, trust me, we have been there before and we are happy to take a look at it for you.